Stella House will be speaking regarding Hoskins Cemetery.
Needed one. I've got a couple more. If anybody else wants one.
I got a master that's out today. There's 3 of us there.
Okay, should I just put one here for him? Okay.
Stella,
Thank you.
let's have one of those.
Huh?
Let's have one of those. Can we?
You want one?
Yeah,
Yeah, there you go. Okay.
thank you.
Also, I have a couple of other things that I'm going to refer to, and I'll go ahead and give you some copies of those. This first thing is the actual property card for the cemetery, showing that it's .379 acres from the DBA's office. And then the next thing is the actual property card showing the 5.190 acres that's right beside it. That is owned by the Board of Education. And that was purchased from the Hoskins family and the Hoskins heirs. Did everybody get one of those? And, next I have a copy of the boundary survey that was, basically went with the deed. And it shows you the a little bit over 5 acre piece of property with the Hoskins Cemetery in yellow on it, so that you can get a visual picture of how the land is and what the size of the cemetery is in comparison to that just 5 acres. But there is also a larger map that I have here that shows a more expansive view of the property, and it shows pretty much, it's cut off a little on one side, but basically the board owns about 140 acres. And so the board is in orange, of course, its boundary, and the cemetery's in yellow. And so this gives you a bigger perspective of the cemetery in relation to the Board of Education's properties around it. And, just to substantiate that that is the Board of Education's property that you're seeing around it, here are the property cards for that additional property. So there's basically 3 property cards for the Board of Education that make up approximately 140 acres of property. And then there's 1 property card for the Hoskins Cemetery that is .379 acres, not even a half acre. And so these are the other 2 property cards for the Board of Education. As I was saying before, attached to this letter, which was earlier delivered to Johnny Johnson and also to the Board of Education, you will find a couple of affidavits. First, you'll find a petition, which when I delivered it to Johnny Johnson, didn't have, and to the Board of Education, didn't have near as many signatures as it has now. Now it has over 2,000 signatures on it. And there's an affidavit from a Gordon Miller, who is knowledgeable about the Native American heritage related to this cemetery, and we've attached documentation regarding the Native Americans buried in this Hoskins Cemetery. And there's also an affidavit of William Charles Tyler Sizemore, who's also related to the Native Americans. And that affidavit regards his family's care and maintenance of this cemetery for almost 60 years. And he is willing to speak later to that aspect of this matter. But basically, I just want to thank the judge and the fiscal court for allowing me to speak today. And I want to thank everyone who took the time out of their schedules to come here today and be a part of this. As all of you, I'm sure know already, I'm here on behalf of the Friends of the Historic Hoskins Cemetery on Island Creek, which includes the burial of Native Americans, U.S. veterans, citizens have loved ones buried there, and then there are many citizens here who are just interested in genealogy or history. And you know, they want to preserve our federal, state, and local history. And this is important to them for that reason. So again, as you know, I'm here to talk to you about the proposed relocation of the Hoskins Cemetery by the Clay County Board of Education. I've already presented the petition to you, showing you that we have over 2,000 signatures of people who oppose this relocation of this cemetery. I also wanted to note, and I don't know how many of you look at Facebook a lot or online, but we do have a group, a Hoskins Cemetery group on there. Family Tree Nuts and some other people have done videos at the Hoskins Cemetery and talked about this matter, and hundreds of thousands of people have viewed these videos. So the eyes of the whole country are watching Clay County right now. And you know, what we want to know is, will they see a county and county officials that respect the rights of the dead and allow them to rest in peace in their chosen resting place? I certainly hope so. Third, I want to discuss the common law on this subject with you. And as most of you probably know, but for anyone who doesn't, I just wanted to explain that the common law is a decision by a court. And that numerous courts in many states, including Kentucky, disfavor disturbing the dead and highly favor allowing the dead to rest in peace. And obviously, many of us are here in support of that today. In 2008, when the Clay County Board of Education purchased the 5.19 acres from Melvin Hoskins heirs, and you have the property card for that, the Clay County Board of Education knew a portion of the land was dedicated to a cemetery, that being the Hoskins Cemetery. You know, they could see that on the survey that was done. They could see that in the description in the deed. They could see that because there's 75 plus tombstones in this cemetery. So there was no problem with the Clay County Board of Education knowing that there was a cemetery on this property. And you know, if the board members had gone out there and looked, they certainly would have known. If they didn't, you know, then they should have. But I think almost everyone in this community knew at that time. And like I said, the surveyor even sectioned out the Hoskins Cemetery, as you can see there. It's 0.397 acres. Or 0.379, I'm sorry. But anyway, and it has its own tax-exempt property card in the PBA's office, as I gave you a copy of. And that card says that it's 0.379 acres and cemetery on North Highway 421. And so, U.S. common law calls for the protection of this sacred ground. As an example, in the matter of N. Ray Hunlick's Creek Cemetery, a Pennsylvania court stated that a dedication of land to a cemetery requires no formality, but occurs by operation of law once burials are made. In Stockton v. Weber, a California court held that one single burial, once made, the cadaver is entitled to protection, and the land containing a human being will be maintained inviolate. In Concordia Cemetery Association v. Minnesota, which was an Illinois case, the court said, what creates a cemetery is the act of setting the ground apart for burial of the dead, marking it, and distinguishing it from the adjoining ground as a place of burial. Well, that's clearly been done here. You know, it has been marked and distinguished and set apart as a place of burial for the deceased. The Hoskins Cemetery has been marked in this way for over 100 years now. I think the oldest tombstone in that cemetery, if I'm not mistaken, is 1893. And, you know, that's over a century ago. So that's a very important part of our history. And also, you will note on the property card that I gave you a copy of, it says the last sale date was December 30th, 1899. Again, that attests to the age of this cemetery. So, it is a well-established principle of common law that once human remains are intentionally placed in real property, such real property and all subsequent owners are burdened by encumbrances in favor of the dead, the kin of the dead, and the public. The dedication of land as a cemetery is in the nature of an irrevocable covenant running with the land. It's an implied contractual relationship that bonds the owner irrevocably to the following. First, the owner cannot remove or disturb any grave. Second, the relatives and friends have unrestricted rights to visit and care for the graves. Third, cemetery property cannot be used by the owner for any purpose inconsistent with cemetery purposes. Fourth, the owner cannot reduce the size of the land set apart as a cemetery. Thus, when human remains are intentionally placed in real property with the consent of the owner, the common law recognizes that the character of such real property has been perpetually transformed. It has been changed forever. Whatever may be the mode of acquisition, and however the title is acquired, it doesn't matter whether it's by descent and distribution, by heirs, by will, by deed, however this property is obtained, they're saying that this property is still protected. Once the land has been devoted to burial, it is no longer subject to mere rules of property law. It is a protected, sacred ground. Now, the vast majority of places in the U.S., burial places in the U.S., like the Hoskins Cemetery, were established informally. Burial rights were granted by the landowner to family and neighbors, and we see that all across Clay County. I know the Fiscal Court has, and the jail, I think Linda's staff has helped with mowing a lot of these cemeteries and keeping these cemeteries up, and I know that's very much appreciated by everyone. And but there is significant protection under the law for these burial grounds, and it comes from the common law doctrines that grant rights to the deceased and to the living. The common law provides that the dead have rights which are committed to the living to protect. For example, in Thompson v. Hickey, a New York court held it was an offense against good morals to mortgage a small plot of ground in a cemetery. Well, imagine what this court would have thought if it had been told the owner wanted to relocate about 80 graves in the cemetery to build a new baseball field. I'm sure it would have been highly shocked by even that idea. More significantly, the dead have the right to an undisturbed repose in perpetuity. In Brewer v. American Medical Alert Group, a Tennessee court ruled that it is well settled that the quiet of the grave is not likely to be disturbed. Good and substantial reasons must be shown before disturbing the dead. Simply stated, the common law disfavors removal of human remains from a grave. As best stated in Pettigrew v. Pettigrew by the Pennsylvania Supreme Court, "Cursed be he that moves my bones," expresses the universal sentiment of humanity. When the Clay County Board of Education acquired the real property from the Hoskins heirs, it was subject to the common law protections afforded to cemeteries. The leading common law case on this subject is Hines v. State. In that case, the Tennessee Supreme Court, this was the Supreme Court of Tennessee, stated that when land has been appropriated to burial purposes, it cannot be conveyed or devised as other property, so as to interfere with the use and purpose to which it has been devoted. When once dedicated to burial purposes and a burial has taken place, the owner holds the title in trust for the benefit of the dead and the living. The owner takes the land subject to this trust. So when someone buys a piece of property knowing that it has a cemetery on it, they buy that piece of property subject to that trust that has been placed in them. In addition, the Tennessee Supreme Court stated that those who purchase property after it has been appropriated to burial purposes take it subject to the implied rights of the deceased and the living without any express reservation in the deed of conveyance. So nothing has to be said in the deed of conveyance to make this the law. There is no requirement for an express reservation in the deed of conveyance. The court added, burial lots are not the subject of trade and commerce, and it is always presumed that they are not included in the sale of property which surrounds them. Similarly, in Humphreys v. Bennett Oil Corporation, the Louisiana Supreme Court recognized the presence of a cemetery on a tract of land fundamentally changes the character of that land such that it cannot be used for anything but a cemetery. Also in A.F. Hutchinson Land Company v. Whitehead, a New York court stated that a cemetery dedication is virtually permanent. Specifically, the court said, so long as the cemetery is kept and preserved as a resting place for the dead, with anything to indicate the existence of graves, or so long as it is known or recognized by the public as a cemetery, it is not abandoned. And as I said, the Sizemore family will speak to the fact that they have maintained this cemetery for almost 60 years. This cemetery definitely is not abandoned. There are no trees grown up on the graves of this cemetery. Pictures taken by Angela here in February with snow on the ground show that this cemetery is well maintained, that, you know, it's not overgrown. It is taken care of. Sure, like all older cemeteries, the tombstones probably could use a cleansing, whatever they do to them to make them look new again after many long years. But this cemetery is by no means abandoned. TJ Finley, who I don't think is here today, but sent me pictures of herself visiting her father, Dewey Finley, at this cemetery, says that she visits there regularly. I know Angela does. I know many of the people in this room visit their family there regularly, so this cemetery is far from abandoned. There was also a Georgia Supreme Court case that upheld access of family, finding that access to property could not be restricted once burials had been made there. So I said all of this to show you that all across the nation, the courts have made rulings that have respected the rights of the dead and the rights of the living to visit with the dead and for these places to be protected in perpetuity. Specifically in Kentucky, there's a case, Rose v. Rose, where Kentucky recognized the right of family to visit a grave cannot be extinguished by the owners through conveyance to another. So in other words, this means that the right of the friends at the Hoskins Cemetery, the friends and family members and loved ones that have people buried there, that cannot be extinguished by the conveyance to the Clay County Board of Education. That right still has to be respected, and Kentucky law has found that. So in conclusion, as best stated by the Louisiana Supreme Court in Humphreys, regardless of the laws and rules relating to the ownership and control of real property, when a plot of ground is set apart for cemetery purpose and burials are made in the land, the ground changes its character in the minds and feelings of the community. It assumes a sacred quality. In this specific instance, the Clay County Board of Education knew that 0.379 acres of land had been set aside for the Hoskins Cemetery before it purchased the adjoining land. In addition, the board members could see physical signs of the Hoskins Cemetery by virtue of the 75-plus tombstones there. As this 0.379 acres had been set aside for burial purposes, the Hoskins heirs held the title in trust for the benefit of the dead and the living, and the Clay County Board of Education purchased the property subject to this trust. Therefore, we, the friends of the Hoskins Cemetery, including family and friends of loved ones, Native Americans, veterans, people that represent all walks of life, are here today to say that these graves should be protected. Some people here today are just interested in genealogy, or they're interested in history. They're interested in preserving our federal, state, and local history, and they want this history protected. So today, on behalf of these people, I implore you to protect the sacred ground and vote no when the Clay County Board of Education requests permission to relocate the Hoskins Cemetery. The Clay County Board of Education owns about 140 acres. I gave you a map that basically shows that. This is a little bit larger size of that map. As you can see, the Hoskins Cemetery is a small yellow speck compared to the 140 acres that's owned by the Clay County Board of Education. So we feel like that the cemetery and the new baseball field should be able to coexist together in some way, form, or fashion, or the Board of Education should be able to find a different spot in this 140 acres for the new baseball cemetery. So with that, I would thank you for your time and attention and ask if we have a veteran and a Native American here that's willing to say a few words if he can speak, and then I have a representative of the Native American family who also did the maintenance that would like to speak briefly.